Welcome back. When we started, Fintank, we said, what are the areas of interest and how do we start building Fintank? And we said, let's organize it. I'm an educator. I've been a dean of a college of business. And I said, it's not up to us to decide what the areas are. It's like, let's look and see what the community wants. So we started to work around this community of practice concept. And we said, okay, what are areas we think are interesting? And people came up with artificial intelligence, blockchain, cybersecurity. And it's one thing to have an idea or a concept. It's to get somebody that can run and make things happen. That's another. And I got to tell you, Zach Smolinski, who's leading the next group, came in. Our first group, we met at our offices. We had like 20 people trying to get it structured, trying to get it together. And now we've outgrown our office. We hold the sessions here. We regularly get 150 to 200 individuals to attend the session. And Zach's been great at making it happen. He's got a great panel here. I don't know if they're going to answer all your legal questions, but they're going to have a good legal conversation. So, Zach, how about it?
Thank you, George, and thanks to everyone in the audience. If the panel members would like to come on up. We've kind of felt like nothing settles the stomach quite so much as hearing some lawyers talk. And so we're hoping to achieve that lesson and also pass on maybe a few legal nuggets as well. We've got a great panel here today of experienced attorneys with a variety of different backgrounds. And so I'm just going to try to leave as much time to the speaking as I can. And I'll just run through some very quick introductions here. We've got Sam Kramer. Sam is a partner at Baker & McKenzie, and he has a focus on outsourcing, complex technology licensing, and commercial contract law. We also have Justin Steffen. Justin is a partner at Jenner & Block, and he focuses on litigation, primarily in complex commercial litigation, financial services, and bankruptcy litigation. Also with us is Colleen Sullivan. Colleen is a managing member at Sullivan Wolf Kalis, and she works on a variety of commercial law matters. She also recently returned from a trade mission to Dubai that was sponsored by the U.S. Department of Commerce. And I think she'll have some good comments about that for us. And to her left is Peter Waltz. Peter is at the Polsinelli Law Firm, and Peter's experienced in transactional law, including the law around SEC regulation. And our final panelist, last but not least, is Anthony Zioli, I apologize. He's a partner at Freeborn and Peters with experience in banking, commercial finance, securities, and corporate law. And so with that, I think I'll just jump right into some questions. First of all, what do you see as the current climate for ICOs in the United States? Is the United States ICO friendly? I've got a couple follow-ups, but maybe let's start there. And Justin, if you wouldn't mind leading off with an answer to that one.
Sure. If you can't hear me, just let me know. I think it's interesting. I think that you probably hear a lot of people talk about the Dow report, the SEC's Dow report, which came out in July and said basically that tokens can be securities. And since that time, I think you've seen the market for ICOs be somewhat tempered, and it was rampant before, but it hasn't been extinguished. I was reading an article that said something like $600 million have been raised through ICOs since July of this year. So it hasn't gone away. And there's been some very large ICOs, like Protocol Labs Filecoin had something like $200 million raised, or over $200 million raised. So they're still happening. It just might not happen as frequent, or they might look different going forward.
And I'll add to that. You said you've seen the market be a little more tempered. I was sort of thinking back over the past year. I feel like I've been a part of a ton of meetings where clients have talked about they're going to do an ICO, and then us as the lawyers start babbling on about the securities laws issues and things they could bump into, et cetera. And people were receptive to that, but kind of blew us off, practically speaking. And now really in the last 6 weeks, we've seen clients and prospective clients who actually are more engaged on that issue, are more concerned about it, and really seem to be understanding this is something they have to tackle if they want to move forward with this or face some pretty big risks.
Yeah, I think that's...
Can you hold your microphones a little closer? That might help. Honestly,
No, I think that's correct. A couple months ago, before the SEC really made any formal, foray into the space, I had calls all the time about people wanting to do ICOs or invest in ICOs, not really understand what an ICO is. And it seemed like we would start talking about securities laws, and no one really wanted to hear a lawyer speak. So now we actually have a say. They are actually looking to us for guidance, and that's why you have even a half-hour panel that has lawyers on it in an ICO space conference, because there is some securities laws concern, and now that the SEC is kind of stepping in and people are realizing that, they're going, oh, well, we should probably check with lawyers before the guys in blue jackets and yellow letters raid our office.
Yeah, I think in addition to that, not only the SEC guidance, but quickly on the heels of the SEC, there were a number of other regulators in other jurisdictions who've issued some similar guidance or cautions, and with the freeze or ban coming out of both China and South Korea, I think people are taking a step back and understanding that there's more legal risk associated with it than they may have thought.
And I would say that there's 2 other practical implementations that should probably help propel this forward. I think just last week we had Marco Santori and Cooley put out the SAFT framework, and I think that will be important for token sales where the product is not developed yet. So there's a framework to bring that to the market. The second is we have T0 now, which is an approved ATS, so we'll have a securities exchange where these tokens that are deemed securities can actually be traded, which I think is critical to have that liquidity.
The other piece I'd tack on to that is when we were describing sort of the reaction from clients and prospective clients, we've seen the same reaction. Our firm represents one of the larger token trading platforms, and they effectively said, yeah, we hear you, for about a year and a half, and now they're all of a sudden serious about looking into registering as a broker-dealer, ATS, tackling that in conjunction with their issues about whether or not they need to be regulated as a money transmitter. So that seems like it's gotten the attention, issuers, platforms, et cetera.
Are you hearing almost a sense of resignation? And I almost get the idea that, folks in the ICO world kind of like the idea that they might not have to talk to attorneys about this stuff. Is that?
I think that's how they wanted to start, but I think once it became a reality and somebody else was getting called on it, it brought all the things that we were saying to our clients before. Oh, yeah, this is what they were talking about. I don't want to be the next person to be called. Let me check in with my attorney.
And that's a little bit, Zach, the nature of the blockchain and Bitcoin community was one of not relying on centralized systems and organizations, but kind of existing outside of those. And unfortunately, there's no real way to escape the impact of the legal system on all sorts of things, from ICOs to crypto exchanges, to other types of activities involving blockchain, not even within the cryptocurrency space. You're getting more regulation in that area, whether you want it or not.
And I might follow that up then with the idea of, it sounds like you're actively being engaged by clients with questions about filing here domestically. Are you also looking at international jurisdictions as potential launching points for ICOs?
Well, our clients certainly are looking at that, and we've got offices in lots of places around the world, and people do start to ask, not is this a good place to have an ICO, but what are the regulations that apply in this jurisdiction should we launch an ICO? And so from that perspective, all you can really talk about is what's the initial guidance that's been given, because you really don't have regulation at this point yet. You have statements, you have cautions, and they tend to be along 2 lines. One is what the SEC started, which is the security versus non-security discussion. And then the other one is more in the nature of consumer protection advice related to scam ICOs.
Yeah, as far as the international side versus the domestic side, I think I've and my firm have been more watching the international side than trying to actually engage in that, because there's just such a flood of money and not seeing the results yet of those investments, whether they've actually been able to create the framework and the tokens that they've intended to do and so on, and whether there's investor concern. So I think we've stayed more on the sidelines in terms of diving into the international side. But as far as the domestic side, I think we're getting a little more comfortable with there being more of a lean towards securities and being more of something to lean on versus just being out there in the openness, especially when you're talking about $200 million type of raises and being cases of first impression. It becomes, we're all working in the dark, and at least if we lean toward the securities, we have some basis of framework to lean on, whether it's only advice or limited types of opinions, we at least have something to work around.
Yeah, I think that, one, I'm glad to hear that I'm not alone, that other people don't like talking to lawyers. It's not just me. But I think part of the tension is that, so ICOs are global, right? They're happening all over the place. But regulation is inherently local or on a nation level, right? So, Sam, I think you alluded to ICOs are banned in China, they're banned in South Korea, but other jurisdictions are more tolerant. So even in the United States, when you go from one state to another, so New York treats cryptocurrency a lot differently than Illinois does, for instance, or Hawaii. So that, I think, is kind of the difficulty in advising in foreign jurisdictions. We are a big law firm, but we don't have law offices in every country. We can affiliate with local lawyers who might have a better perspective on what regulators will or won't do, but it's hard. It's all over the place. And that's the tension there, I think.
Yeah, I think a couple of jurisdictions I've heard of, Gibraltar, the Isle of Man. I don't think I've heard of these things outside of a Jeopardy answer, but somehow they're relevant here. Is this a race to the bottom? Are these countries trying to come forward as being highly deregulatory and thereby attempting to gain a bunch of business for their people? How is that working?
Zach, I think the answer to that is we don't really know yet. What we've got is some press releases and interviews that have happened with some of the regulators in places like Gibraltar and the Isle of Man, where they're talking about issuing a regulatory framework that is friendly towards ICOs. What exactly friendly towards ICOs is, we don't really know. We saw it before with data havens, where companies were doing that. We see it in the banking world, with countries that have very strict bank secrecy laws. But what it actually means from the ICO perspective, it's really a wait and see type of game, because until you see actual regulation, you won't know what the impact is going to be.
And we see clients talk about Singapore a lot, and how it's the end-all, be-all and great. But I think it's, as you said, no one really knows what that means in practice.
Well, the MAS in Singapore has come out with guidance that's not all that different from the SEC in terms of, be careful. It's very possible, in fact, probable that your ICO is going to, result in the token being a security. And that's really where the focus has been, I think, in terms of the guidance that we've seen around crypto. A lot of it has been in this issue of, is it a security, is it not a security? And the regulators feel fairly comfortable when they understand that something is a security and what that means, and a little less comfortable about, right, yeah, a little less comfortable about when it's not a security. Okay, well, what kind of protections are there? What prudential standards should be applied to them? They don't really have a framework for it yet.
As an attorney, and it gives me a little bit of an upset stomach seeing all the articles intended to, this is how you structure it not to be a security, to avoid securities laws. That always makes my stomach hurt, because it just, I don't know, it makes me cringe. I don't know. I would worry that somebody is trying to rely on this guidance that could change, instantly, because the SEC is, frankly, it's a dinosaur. It's slow to catch up to fast-moving technology, which is blockchain and things. But if you're intentionally structuring things to avoid laws, that's where it gets me nervous. So I think at least with the SEC setting its foot here, we're seeing less of these articles and advice given to avoid laws, and more of, you're probably under this. This is the simplest way to go with the flow.
I think that's a good lead into the concept that, to me, regulation's not just a spectrum. It's not you're either highly regulated or you're unregulated, that there are a number of contours between. And so, Colleen, I wonder if you could sort of fill us in on what do you see as being useful guidelines for regulation? How do you make regulations and live with regulations so that they work in a way that benefits everyone?
Let's see. That's a big question.
Sorry, you can just take a smaller piece of it if you like.
Yeah, well, I can tell you just a recent interesting perspective on regulation. So as Zach mentioned, I was part of a U.S. Department of Commerce certified trade mission to the UAE to exchange ideas on blockchain technology. And if you're not familiar with it, Dubai has something called Smart Dubai, where the leadership of Dubai has said that they will be the first world government powered by blockchain technology by 2020. And after leaving, I can tell you for sure that it is self-fulfilling there. If the leaders say that that's what will happen by 2020, it will happen, and it will be implemented on time, and it will be done well. So the Dubai government has hired IBM and Consensus as its strategic partners to identify different use cases for blockchain technology. They've identified 27 since March of 2017. They're putting those 27 out for bid now, and they will become implemented in 2018. And we're talking about a range of services from healthcare, land titles, vital records, I mean, you name it. And what's happened there from a regulatory standpoint is that the regulations have to change to accommodate these use cases. And that is what is in fact happening there. So they're changing the law to accommodate these different blockchain technology use cases. I think here in the US, obviously we're not as nimble as Dubai. And what we've done with my clients who are primarily in the trading industry is we've sort of done a gap analysis between what types of rules and regulations apply in the traditional securities and commodities trading world versus what is going on in the crypto space. And we do that gap analysis and we pull out best practices. So, you know, there's no prime broker in the space, right? So we have direct counterparty risk to each exchange. So how should we evaluate our counterparty risk? We have to look at things like security, hacking, do they socialize losses, those different types of things. And that's really, it's almost been just self-imposed best practices while we're kind of waiting for the regulators to catch up.
I think as a tack onto that, I think, you know, nationally here to actually get some form of real regulatory structure is going to be bumpy at best and take a long time. And this goes to any form of new financing, you know, anything from the Jobs Act, from peer-to-peer. It's just been trying to take antiquated laws and make them work for things that they were never intended to do. Whereas if we could do things like the UK that would scrap portions of that law and literally rewrite them to specifically address these specific concerns, it would be a lot faster. I don't think that's going to happen, but I think that would be, especially when you're dealing with cryptocurrencies and such sophisticated technologies, that it would require a fundamental rewrite of certain portions of the law to really create a smooth working framework. Until then, we're going to be bumping against antiquated laws and having to do that, and again, relying strictly on attorneys' concepts of best practices in a lot of different areas.
Yeah, and I will add too, it's tricky as an attorney to develop best practices because you need to understand the technology. And getting into that, like you sort of need to sit with your client's CTO and make sure that you're close to that, because how do you advise on best practices if you don't understand the underlying technology? So that's been interesting too.
Yeah, I would say that in my own practice, it's difficult sometimes to get clients to listen to cautionary advice. It's often it's easier to get their attention when it's in a reactive case. Do we need more cautionary tales of ICOs gone awry?
I think the good news, at least the SEC has not been overly dramatic about, you know, they're very kind of smacking the hand right now. I think at some point, you know, it'll be a lot worse, and that will send people running to lawyers. I think right now, at least, with just the little foray that they've done to it so far, has given at least people the impetus of concern to seek out answers. So I think that's helpful. Whether there are other cases of that, I wouldn't, you know, I don't want to see more cases be in trouble, but I would like to see more guidance in general from any regulatory body, whether it's, you know, the financial industry saying cryptocurrency is a security and go in that direction, or vice versa.
I think the other perspective, when you compare kind of rest of world to the United States, we are slow moving, and I think, you know, the reason for that is varied, but we've got a dual regulatory system at the federal and the state level, and then we have the overlapping jurisdiction of a number of our federal regulators. So the CFTC says it's a commodity, and we've got state regulators who are saying it's money, and we've got a whole lot of other regulators who haven't weighed in on that just yet. So trying to straighten that out and get harmonization is more difficult than in a place, even a more mature jurisdiction like the UK, where you have the FCA that's essentially going to issue the regulations in that area.
So I just checked my watch, and time is just flying by here. So I'm going to ask one more question, and I think I'd like to open it up to anyone who wants to step up to the microphone and grab the microphone in the audience. But we've talked about regulatory law quite a bit, and I'm wondering if any of the attorneys on the panel have experience with clients coming to them with blockchain-related items outside of the regulatory space.
Sure, we actually have a number of clients who've come to us very interested in the use of blockchain in the supply chain for verification purposes, anti-counterfeiting. There's some pretty interesting use cases. It's still something that's really in its infancy, and you're talking about more piloting than anything else, but I think that's going to be a huge area. Also interest on lots of companies who are involved generally in Internet of Things, in smart contracts engaged in by smart devices.
Yeah, I think the clients that have come to me, at least they've been more questioning what blockchain is and how it can help them. But then when you start explaining to them, okay, it's a supply chain process, for example, that they want to use it on as a hard asset type of tracking. When you start getting into the types of technology it would require and the upfront cost, they kind of just, maybe we'll think about it down the line when it's easier. So I haven't seen many that have actually moved forward when it's not into the more regulated industries of finance or things like that.
And at our firm, we do a fair amount of healthcare work, and we have seen hospital systems asking about it for things like patient records. We've seen folks talking about it in terms of clinical trial data, and then also a client that is involved in the payment space in the healthcare area. So we've seen a lot of questions really around various things in the healthcare industry.
I would echo what the other panelists have said. The main areas that I've heard a lot of people interested in are vital records and supply chain. I think if you could go and look in any article on CoinDesk and see, I think Colleen said there's 27 use cases that Dubai was looking at. 27 use cases Dubai's looking at. I've heard of more, right? Everybody hears blockchain and they get excited now. It's a lot easier to get in and talk to people about blockchain than it used to be. But just because it's exciting or people are raising a lot of money doesn't mean you should do it. I think a lot of the times people don't like talking to lawyers because they think we're killjoys or something like that. But we really want you to focus on, can you do it and should you do it? Can you do it legally? And even if you can do it legally, whether it makes sense for your business. So can you run down the street naked? You can, but should you?
Not legally.
Well, fair. There's risks there, but should you? That's another question. And we just want you to think about that, I think, and whether being on the blockchain makes sense for you, whether tokenizing your product makes sense for you. It doesn't make sense for everything. So we're not trying to be killjoys, I'm trying to say, I guess.
And I'll add to that, our firm recently got engaged. We're defending someone who's the subject of an SEC enforcement action. They got slapped with a bunch of bad things: fraud, violating the securities laws with respect to a token offering, and the amount they raised was something like $280,000. So these guys are going to spend who knows how much to defend this. Right, because they didn't probably. And one of the things they've said is, "Gosh, I didn't know we were doing something wrong. Everyone else is doing it. We didn't mean it, but none of that really matters in the eyes of the SEC once they come after you."
It's like my favorite line when I tell clients, "Oh, you should have come to me 2 weeks ago." Yeah, came to me now. I'll try to help you out.
I think we do have about 1 minute. If anyone in the audience has a topic that we haven't covered that you'd like to hear about, feel free to chime in. Yes.
No one ever has questions for lawyers.
Thanks. I'll repeat that question. The question is, how do you see cronyism manifesting itself in the form of regulation of ICOs? To be more specific, would this be, say, like the revolving door, regulators who are industry players, or vice versa? Okay.
I think in this space, it's far too early. We don't even have regulation yet. And the first guidance really was SEC in July, I think July 24th. So maybe watch this space to see what happens, but I haven't heard of anything like that yet.
No, I mean, we've seen it a little bit with like the New York bit license where Losky then left to go do consulting, but not in the ICO space. There's nothing yet.
And we see people complain about it, right? As they don't know, do they need to deal with the CFTC on this issue, or the FinCEN or SEC? So we see people throwing up their hands and saying, I don't know what we're supposed to do, because there isn't the cronyism or the synergy amongst the regulators.
Got a question in back there, too. If you could speak up.
Sure, yeah, it's interesting. Their vision statement is that they want to make Dubai the happiest city on earth. And that's literally their vision. But their thought is that through embracing technology, they will have happier citizens who, just for ease of use, you'll be able to have a digitized identity where you just check in with your passport. And this is for both residents and visitors to the UAE. But that is sort of the overarching mission, is they want to make, and I should say, kind of to the point made earlier, they were very clear that they're just not blockchaining to blockchain, that if something was not broke, there was no need to fix it. And they had a very simple checklist to determine if services should be put on a blockchain or not. And that is just, does the service, would it benefit from distributed ledger? Does the information need to be cryptographically secured? And is there a need for immutability? And if those services scored high on that very simple list, then they were moved over into consideration for use case. Yeah. Oh, so now I think they do, well, so cryptocurrencies and blockchain technology I would sort of view as two different things. And I think they're careful to separate the two, where they're definitely moving forward with use of the blockchain technology itself to put services on blockchain. But as far as cryptocurrency, I would say, so right now there's only one cryptocurrency exchange in Dubai, BitOasis. I would say they're kind of behind a little bit where we are just in terms of trading crypto. And as far as digitizing their currency, we did speak with the central bank, and the central bank is taking a very cautious approach, and they are definitely not up for multiple cryptocurrencies that are not pegged to the dirham. So I mean, that I would say they're more cautious with the just sort of traditional cryptocurrency space.
We're doing that on a national level too, in terms of trying to blockchain certain cities. I'm working with clients in certain cities, and they're looking at putting certain types of records specifically on blockchain for no reason other than blockchain is, the need for immutable ledger, and it actually makes sense. There's not an end for a cryptocurrency, but smart cities are popping up throughout the nation trying to equate those technologies specifically. Problem is they end up running into other types of laws, like when you do health records, do those identities become HIPAA compliant and so on and so forth. So it's a little bit slower here because we have so many different regulated industries that you end up bumping into some wall somewhere.
So with that, I'm afraid we are out of time. So I would encourage to continue the conversation, collar me or any of our other panelists during the networking portion. Thank you very much to the panelists, and thank you for everyone in the audience.